may be seated. I see that counsel for our second case set on our 9 o'clock docket is aware that our first case has been vacated for this morning's argument, so we just have one case on our 9 a.m. docket. I assume this is counsel for, is it Joya? Is that, okay. Joya versus Clark. Has counsel had an opportunity to review our procedures?
Yes, Your Honor.
Yes, sir. Okay. And I guess before we get started, welcome to Division 3 of the Colorado Court of Appeals. My name is Craig Welling. To my right is Judge John Webb, and to my left is Judge Elizabeth Harris. If we're ready to proceed, then we'll go ahead and begin. I know there's an appeal and a cross appeal. What I'm going to ask is that the appellants go first. You can reserve whatever time you want for rebuttal, but if the respondents / cross appellants would just address their argument in full, I'm not going to do the back and forth, if that makes sense. Okay, very good. Then with that said, 17CA1461, we'll go ahead and begin. Counsel.
May it please the court. Good morning, Your Honors. My name is Jennifer Osgood of Chipman Glasser, LLC, registration number 35070. I represent appellant Michael Joya in this matter. This case involves a dispute between two members of a manager-managed Colorado limited liability company, BIMShift LLC. BIMShift provided technology services for the construction industry. The two members of BIMShift included Mr. Joya as well as appellee, Mr. Justin Clark, each owning a 50% ownership interest in the company, with Mr. Clark being the managing member of BIMShift LLC. Although the parties were having their most profitable year ever, in September of 2015, there was a falling out regarding the status of the company as well as the division of labor between those parties. Following this argument, my client, Mr. Joya, believed that they had reconciled and that they would be moving forward business as usual. This was not, in fact, the case. In reality, Mr. Clark began surreptitiously siphoning off both active and current BIMShift projects, as well as opportunities to a company that was owned solely by him, J.R. Clark Enterprises. Not only was Mr. Clark transferring these existing BIMShift projects to his own entity, Clark Enterprises, he was even invoicing through this entity, Clark Enterprises, for work that had previously been performed by BIMShift. At the trial court below, following a 3-day bench trial, the court found in favor of Mr. Joya on his claim for implied covenant of good faith and fair dealing against Mr. Clark. The trial court also found in favor of Mr. Joya on his claim for conversion against Clark Enterprises. Ultimately, the court entered an order of dissolution, dissolving BIMShift LLC. The issue, however, is that the trial court dismissed Mr. Joya's claim for breach of fiduciary duty. In addition to that, the trial court failed to consider certain damages other than the amounts that Clark Enterprises was paid for work that had been performed by BIMShift, and those are really the crux of the issue that formed the basis of our appeal here today. There are 4 total issues presented on appeal, 3 of which come from appellant, 1 coming from appellee. At least with respect to all the issues that we have raised, the crux of the argument has to do with a manager's duties within the constructs of a manager-managed Colorado limited liability company. I intend to focus my argument today on the first issue that we presented, whether the trial court erred in determining that based upon the existence of a written operating agreement, Mr. Joya's claim for breach of fiduciary duty should be barred by the economic loss rule.
Before you get there,
Sure.
Given the relief you sought, what difference would it make whether your subsidiary claims were analyzed on the basis of the statutory duties or on the basis of the good faith obligation in the operating agreement, or as the trial court, I guess, recharacterized it, an implied covenant of good faith and fair dealing? I mean, it's a practical matter. What more do you get out of the statute?
The statutories that we're primarily focused on are those that arise out of CRS 78404 under the Limited Liability Company Act. And those duties are substantially different from the duties that are memorialized in the operating agreement. The operating agreement itself is relatively devoid of what the manager's duties are. There's a section 5.8 in the operating agreement that is titled Manager's Duties, but thereafter doesn't really go in to describe what their duties are. It does describe arguably a standard of care in which duties are to be performed, but the section also within the operating agreement says that controlling Colorado law is going to apply here, which in this case we would look to all of those duties under the LLC Act, which would include specifically those duties under 404. I think as a result of the court's dismissal of the breach of fiduciary duty claim and its relief provided solely with respect to the breach of covenant of implied good faith and fair dealing, it doesn't specifically address those statutory duties, which are focused on accounting back to the limited liability company for all the profit and benefit that is derived in the dissolution of the company. And this includes not just profit, not just property, not just benefit, but it also includes lost opportunities. So to the extent that opportunities were usurped from BIMShift and taken to Clark Enterprises, that is something that the court did not focus on in its analysis, in my view, because it had dismissed the breach of fiduciary duty claim.
And even under the unfinished business rule in LaFond, you still think you have a stronger case based on the statutory duties?
I do. There's not many cases in Colorado that specifically address how damages should be addressed under Section 404 of the Limited Liability Company. Your Honor mentions one, LaFond v. Sweeney, and I think LaFond v. Sweeney is very instructive in this case. In that case, you had, again, a Colorado Limited Liability Company with two members, each owning 50% ownership interest in that company. That company happened to be a law firm. I don't think that makes a material difference for purposes of this analysis. But very much like this case, you had co-owners who had an agreement that regardless of who did the work, that they would share profits equally on a 50-50 basis. And that's likewise what we have here. In that matter, the pending contract was a contingent fee agreement. And ultimately, this court and later the Supreme Court found that Mr. LaFond, who continued to work on the contingent fee matter after he left LaFond and Sweeney, or LaFond and Sweeney started winding up, that he was responsible to account back to the law firm, LaFond and Sweeney, the entirety of the contingency fee matter, or the entirety of the contingency fee itself. And that is essentially the relief that we're requesting here, that had the court properly analyzed its duties, or Mr. Clark's duties as a manager, that he had continuing duties both prior to and during the dissolution and wind-up of BIMShift LLC, and that included continuing to perform under the existing BIMShift contracts, as well as not to usurp those existing projects for himself, for his own personal benefit through Clark Enterprises.
So, counsel, can I ask a quick clarifying question?
Sure.
So you identified lost opportunity as being sort of the damages that you could get from the statutory duties that may not be in the operating agreement. Is there anything else other than lost opportunity that you need the statutory duties to apply?
So to clarify, and again, I believe this is because the trial court's focus was just on the breach of the covenant of implied good faith and fair dealing, that all the court awarded BIMShift, and ultimately half of which went to Mr. Joya, was just those amounts that had been paid to Clark Enterprises for work already performed by BIMShift LLC. What it did not do was account for any monies that continued to be paid for Clark Enterprises based upon additional work that it performed under existing contracts or these lost opportunities, contracts that it rebid for.
Okay, so those two sets of damages, and is it your position, though, that you can't get those damages unless the statutory duties are applied?
So,
Or that the operating agreement itself would allow for those categories of damages?
and the question that you're asking, I think, drives to the second issue that we presented before the court. It is our view that those damages should be recoverable both under the operating agreement of BIMShift as well as under the 404 statutory duties. However, I would concede that it is more clear under the 404 duties. So the way our issue 2 is postured is that it was both an error to dismiss the claim for breach of fiduciary duty based upon the economic loss rule, but likewise, whether you're analyzing the damages in the context of a breach of fiduciary duty claim or as a breach of implied covenant of good faith and fair dealing under the contractual claim, that those damages should be reached, although the duties are expressly more clear under the LLC Act, under Section 404, than they are in any other, within the contract itself.
Okay, thank you.
I see that I have a little less than 5 minutes, so I'm going to reserve the remainder of my time for rebuttal.
Very good. Thank you, counsel.
Thank you.
May it please the court. My name is Brett Lilly. I'm here with Scott Hale at council table, and we represent the defendants in this case. I'll start where plaintiff started, and then I'll hit our cross appeal. I think as an overview, the trial court correctly accounted for all the projects, profits, and opportunities of BIMShift, and our position is the trial court order on that part should be affirmed. To take the fiduciary duty claim, I think it's important to recognize, as I think this court's questions indicate, that the duties, when you're talking about an LLC, are only either under the statute, the LLC Act, or the operating agreement. There's no common law tort claims. In fact, there's no common law claims otherwise. So if we're talking about statutory duties that we label fiduciary, that's not the same thing as a common law fiduciary duty claim. And I think that gets important, even though they bring it up, that under a common law claim, you can have issues like attorney fees. And I think it's pretty clear the legislator didn't intend that to apply here. And so there's a big difference between statutory duties and common law duties when you're talking about a quote-unquote fiduciary duty claim. Here, I think it's pretty clear the operating agreement does control. That's section 5.8.1 and 5.9.1. Both of those limit liability to the operating agreement itself. But arguendo, if the operating agreement doesn't apply, the duties under the LLC Act are not independent. The trial court specifically found that the conduct complained of in all of the plaintiff's claims was covered by the same duty either under the operating agreement or under the LLC Act. And to get to your question, Judge Webb, that leads to the fourth point, which is that arguendo, if the operating agreement doesn't apply and you're looking at the LLC Act, there's no independent damages. And I think specifically if you look at the court file, page 442, that's page 131 of the trial court's order. And there's never been a compelling answer to that. In fact, because there's not a compelling answer to that, the trial court examined all of the evidence that the plaintiffs presented to this court and to the trial court and found that all the profits, projects, and opportunities that belonged to BIMShift went back into BIMShift. And I think that accounting has never really been answered by the plaintiffs.
Well, let me try to clarify that.
Sure.
As I understand, or perhaps misunderstand, there's essentially three categories of potential unfair competition profits. There's the the work that BIMShift actually did, but Clark Enterprises invoiced for and collected, correct? I mean, there are some damages in that category.
According to the trial court, yes.
Okay. Then there's another category where the contract resided in BIMShift, but it was taken over and ultimately performed by Clark Enterprises, correct?
I don't know that the trial court pointed out any of those examples, Your Honor. And I think to take that point, this is construction modeling, and so it's very competitive. And so a lot of the confusion arises from the fact that just because a bid is made on a case by BIMShift doesn't mean that that contract or that project is then awarded to BIMShift.
Well, weren't there projects on which BIMShift had been the successful bidder, but Clark Enterprises took over and completed?
Yes, and I believe the trial court accounted for all of those.
You mean, by accounted, you mean give BIMShift damages?
The trial court specifically found that, yes, I guess damages is the appropriate word. In other words, the trial court said, look, these were BIMShift projects. The work was either finished by Clark Enterprises or the money was collected by Clark Enterprises, and all of that money, which was roughly half of it was $40,000, went back into BIMShift. The $80,000 went back into BIMShift, and the half of that was then allocated to Mr. Joya as damages.
Thank you.
I guess the deeper answer to your question, Your Honor, is that since we're talking about the evidence and we're talking about the damages, the overarching theme this court should recognize is that those are all matters of deference to the trial court, right? The trial court examined the credibility of the witnesses. The trial court examined all the evidence for damages. And the plaintiffs haven't pointed out anything that the trial court didn't examine. So I think when we're looking at the standard of review, this court should be very deferential to the trial court's resolution of all of those questions. Let me briefly, let's just finish that. Since we're talking about damages, I think that even if you said the operating agreement doesn't apply and the duties under the LLC Act aren't independent, there's, like I said, never been an answer to paragraph 131 of the trial court's order that Mr. Goya did not sustain damages separate and apart from the damages the court otherwise awards. In other words, the trial court examined all of the evidence that Mr. Goya submitted, and that was the conclusion that the trial court came to. And just as the trial court said, just as the conversion claim has duplicative damages, the same is true of any fiduciary duty or other statutory claim under the LLC Act. And so the damages of economic loss are exactly the same and are duplicative of any damages of what the trial court examined under the good faith claim.
But the what you call the conversion damages were limited to work actually performed by BIMShift, but billed and collected by Clark Enterprises, correct?
Well, I think there are two categories there, Your Honor, not just work done by BIMShift, but work that was also done by Clark Enterprises. The trial court found some of that and put that back into BIMShift, I think on the Mercedes-Benz project in particular. The trial court order, I think, was pretty clear in terms of laying out where he was finding that evidence, and he was also pretty clear that the evidence submitted by the plaintiff wasn't very clear in terms of trying to make these additional arguments that they're making. So I think that's another factor that you have to consider in sort of giving deference to the trial court. Quickly, I want to point out that the legislators specifically indicated in two places that there's no tort claims under the LLC Act. That's 780-1071 and 780-109. And both of those indicate that the LLC Act is in derogation of the common law. And the Weinstein case held that these provisions means that no common law applies. Only specific statutory authority under the LLC Act creates a duty. And I think it's important there that the court in Weinstein overruled Sheffield for improperly extending the common law tort of fiduciary duty to managers and creditors where the LLC Act didn't. So I think that's pretty clear indication that the universe we're dealing with when we talk about LLCs is either the operating agreement or the LLC Act. It's not any common law duty. To briefly hit on LaFond, I think 2 points. It's important to remember that it was amended by the legislator when the legislator passed 17CA0015, which allows for reasonable compensation in the winding up. So I think that changes the analysis a little bit of how LaFond applies. I think what LaFond really stands for is what is the business of the LLC. And so turning briefly to what the business of the LLC is, that's the phrase used under section 78404. It talks about businesses and opportunities of BIMShift. And I think, as I said, the term business is the key to holding it of LaFond. What is the business of the LLC? And another aspect that's never been addressed by plaintiffs is that the trial court was very clear to say at the point that BIMShift was no longer viable, which was somewhere in the fall and certainly by December of 2015, and certainly by the beginning of 2016, if the business is no longer viable, then there's no more projects, there's no more business, there's no more opportunities, and so at that point, there's no competing with the LLC, and everybody's free to move on.
Well, but how do you reconcile what you just said with the unfinished business rule of LaFond? And I appreciate you and I may have a little different perception of the evidence, but indulge me. I mean, my perception is that there were projects on which BIMShift had been the successful bidder, but because the company tanked, Clark Enterprises took over the project, did the work, billed for the work, and got paid. So if accepting my characterization, why wouldn't that be within the ambit of the unfinished business rule as announced in LaFond?
Well, I think it is, and I think that's what the trial court found, Your Honor. In other words,
So you think that the trial court awarded damages for all projects on which BIMShift was the successful bidder, but Clark Enterprises actually did some or most of the work, billed for that work, and collected for that work?
absolutely, yes.
Okay, I'm sorry, can I jump in? Because I
Yes.
think maybe there's like a semantics problem or something here. Are you saying that, yes, absolutely, the trial court accounted for that by giving back to the LLC the money for the work done by the LLC, but not the completed profits from that project?
Well, I think you're raising an excellent point, Your Honor. The trial court, let me put it this way, the trial court found all BIMShift projects and opportunities. It figured out what those were, whether they were done by BIMShift or whether they were done by Clark Enterprises, and put those back. Now, to jump to our cross appeal, our problem is how he put them back. In other words, he took half and awarded it as damages. Let's just say it was $80,000. He said half of that goes to Mr. Clark, half of that goes to Mr. Goya, and that's the damages. And what we're saying is that under the winding up statute, under 813.2, what that money should have done is actually gone back into BIMShift itself as a matter of accounting. Then they should have netted out all the assets and liabilities, and then the check, if any, to Mr. Joy at that point should come from BIMShift and should be reflected on his K-1. So he did what Judge Webb is asking about in the sense that he figured out what belongs to BIMShift, what are BIMShift projects, what are BIMShift opportunities, and put those back on the BIMShift side of the ledger, so to speak. But what he failed to do under 813.2 was actually account for the assets and liabilities in the winding up. In other words, long story short, the check, one way or the other, should come out of BIMShift. It shouldn't have come from Mr. Clark. So I think he accounted for the business and the opportunities in terms of moving it from one side of the ledger to the other. In terms of accounting, who writes the check to who, the money didn't go back into the BIMShift bank account like it should have. And that's the problem that we have to jump ahead to the winding up part of the statute.
Well, then,
Well-
can I just, I'm sorry, go ahead.
Well, but BIMShift was not a party to this case, correct?
Yes, it is.
So it was a named plaintiff or defendant?
Oh, yes. I'm running out of time, and I want to really quickly hit our cross appeal. So the first thing I want to talk about on the cross appeal is that there's a big difference between a judicial supervision, which is only permitted under an LLC that has been dissolved by voluntary action, and that's 810-4A. And if you have an LLC dissolved by voluntary action, then you can permissively ask for judicial supervision. That's not the case here. What we have here is a judicial dissolution. That's under 810-2. And our argument is that under 810-2, if you have a judicial dissolution, the winding up provision of 813-2 is mandatory. And the case law that we cited indicates that the shall direct the winding up and liquidation in accordance with 803 means that the liabilities need to be wrapped up and netted out, and that has to happen before any judgment is final and appealable. So to finish the point with you, Judge Harris, that's what we're saying is that even though the trial court correctly figured out all the BIM shift projects and opportunities as a matter of financial accounting as opposed to judicial accounting, that money should have been in the BIM shift checking account. Then the trial court should have said, look, here are all the liabilities, including Super Punch, which is a major liability, which is still unresolved. And then once those liabilities are resolved, you net out the difference in whatever the checks are to each party, that's what they get. So we think that it's very important that the court should give clear direction to the trial court on how to proceed in winding up a judicial dissolution and outlining what steps are necessary to complete a judicial dissolution. And most importantly, hold that only a final accounting and winding up is the final appealable order. Briefly, the problem that you have if you don't allow that is what happened in this case, which is that there's a judgment for damages. They filed a garnishment and started collecting on that judgment for damages. And at the same time, then they filed a notice of appeal. And so we've got these kind of cross tracks going on. Do we have the case of damages? Do we have the case of winding up? And our position is that once the notice of appeal is filed, the trial court loses jurisdiction. And so we can't go back to the trial court with the winding up issues until the appeal is wrapped up. So what we're saying is that absent a Rule 54 issue, in the normal case with a judicial dissolution, both the damages and the winding up and liquidation of all the liabilities needs to be all one order. That is the final order, and that is the appealable order, and that's what we would like this court to hold.
Very good. Thank you, counsel.
Thank you, Your Honor.
Not good.
Thank you, Your Honors. The first issue that I wanted to respond to was something that I don't believe that was contained in the briefing, but I do think is important, so I just wanted to briefly touch upon it. And that is Mr. Lilly's reference to the amendment that following LaFond and Sweeney was made to CRS 78404. He mentioned that subsection 6 was added. Subsection 6 of this statute does allow for the member or manager who is responsible for the winding up to receive some remuneration for those services. But I wanted to point out that that amendment did not occur until after the acts that are complained of here, and therefore I don't think that has any basis in the court's analysis, and that LaFond and Sweeney would still be the controlling law on that point.
Before you move on, is BIM Shift a party to this case?
BIM Shift, to my understanding, was included as a nominal defendant, but it was an unrepresented nominal defendant in this case.
So it was named as a defendant in the complaint?
My understanding, it was named as a complaint. It appears in the caption. It was not represented in the trial court proceedings below.
Okay. Next question, because I apparently have a different perception. Are there projects on which BIM Shift was the successful bidder? Clark Enterprises ended up doing most and perhaps all the work, invoiced for that work and got paid for it, but no damages were awarded.
Yes.
Thank you.
And I think that's clear in the trial court's order as well. In the briefing, I identified just one of these instances to provide an example, short of having to go through absolutely every pending project at the time. The example that I provided was the Mercedes-Benz case. This was a case in which BIM Shift bid the project. They were the successful bidder. They performed services. Clark Enterprises ultimately took over, completed additional work, and then invoiced Mercedes-Benz for both the work that it had performed as well as the work that BIMShift had performed. It is clear based upon the trial court's order that it only awarded BIMShift those amounts for work that it had performed. It specifically excluded and carved out those monies for Clark Enterprises based upon the work that Clark Enterprises has performed. And it is our position is those are the types of damages that should have been captured in Mr. Joya's breach of fiduciary duty claim that ultimately, because it was dismissed as barred as part of the economic loss rule, the court did not capture in its analysis.
But you still contend that you have an independent basis, even if we don't agree with you on the breach of fiduciary duty, that under LaFond you're still entitled to those with or without that claim surviving?
With or without that claim surviving, I believe that the duties, as I mentioned earlier, prescribed in 404 are clearer than what exists under the operating agreement, but I think you could reach the same result. Again, because the duties are different, the relief that you're seeking is different in our view, that it should be analyzed both under the construct of the operating agreement as well as the breach of fiduciary duty claim.
Did you want to address any aspects of the cross appeal?
I did, Your Honor. And that'll kind of bring me to my last point. From a procedural standpoint, I find it a little bit difficult to believe that Mr. Clark can now raise the issue that the April 27th order was not a final appealable order. They identified in their notice of cross appeal that they believed it to be a final appealable order, and to the extent that they disagreed with our characterization, I think the relief should have been sought earlier in some form of a motion to dismiss our appeal, because it believed that there was still relief that the trial court needed to afford the parties before an appeal moved forward. From our perspective, there is no unfairness in this issue. The damages that were awarded not only against Mr. Clark personally, but J.R. Clark Enterprises. There is nothing that should have precluded us from being able to collect those. In addition, we're also dealing with funds that had been enjoyed by Mr. Clark for some period of time to the detriment of our client. So ultimately, the relief that we're requesting here is that the trial court's dismissal of Mr. Goya's breach of fiduciary claim should be reversed. Likewise, the trial court's order, to the extent that it failed to capture these damages, likewise be reversed. In all other respects, we believe the trial court's order should be affirmed.
Thank you very much.
Thank you.
The case will stand as submitted. Written order will issue in due course. I want to thank counsel for their fine briefing as well as argument today. And with that said, you are free to go. And do we have, you can pack up your stuff. I'm going to be, the folks for people in the interest of JS, do we have both sides here or just one right now?
Your Honor, we have both sides, but one has stepped out, and we haven't had a chance to tell them about the change.
Okay. So why don't we go ahead and take a brief recess and come back for our 10 o'clock docket. We may be able to come back early if the bailiff would just go ahead and inform us when everybody's ready to go. We'll go ahead and reconvene. So we'll be in recess. may be seated. Welcome back to Division 3 of the Colorado Court of Appeals. I'm Judge Welling. To my right is Judge Webb, and to my left is Judge Harris. We have one remaining case for this morning on our 10 a.m. docket, and that's People in the Interest of J.S. Is counsel prepared to proceed?
Yes, Your Honor.
Any questions before we do so? One thing I would remind everybody of is that the arguments are being streamed and archived on our website. So it's very important that you stick to initials or titles of mother, father, and not names, and be sensitive to that fact as you present the argument this morning. And with that said, it'll be 15 minutes per side, beginning with the appellant.
Good morning. May it please the court. My name is Aaron Belzer. I'm here on behalf of appellant, who I'll be referring to as husband. My bar registration number is 47826. Your Honors, for the first time in Colorado, this court is asked to answer the question posed by our Supreme Court in the NAH case, which is whether there are indeed two competing presumptions of paternity. All of the case law thus far has addressed a counterfactual situation where there are where two men have established competing presumptions of paternity. Here, however, we have one man, husband, who had already attained the status of legal father, and another man who was merely an interested party. NAH is explicit that in any proceeding ostensibly between two competing presumptions, quote, the first question must be whether there are genuine competing presumptions or whether one of the men who claims fatherhood is entitled to a conclusive determination.
Counsel, at some point as you develop that argument, I'd like you to explain exactly how this issue was preserved and is properly before us, because as I understand it, but please feel free to correct me if I'm wrong, mother raised the issue in a motion. I'm trying to keep husband and father straight, but she was the only, husband was not a party at the time. As I read the record, husband never re-raised that issue nor in any way requested the trial court to rule on it. So, and quarrel with what I've said whenever you wish, but at some point, at least from that perspective, I'd like you to address preservation.
Sure, Your Honor. I'll address it now if that's okay.
Up to you.
The issue was brought to the attention of the trial court by mother before the trial court added husband as a party.
Was that in the emergency motion for a stay of the genetic testing order?
That's right, Your Honor. It was raised there. And I forgot to mention at the beginning, I would like to reserve maybe 2 or 3 minutes for rebuttal at the end. So if I
Let you go ahead and
bail
manage
out
that.
on you, I apologize. Mother raised the issue in the motion that Judge Welling just mentioned, and it was also argued at one of the pretrial hearings by mother's counsel. By the time father was added to the case, the court had made it clear in its supplemental ruling on the motion to dismiss, or the supplemental order on the motion to dismiss, that it would not be addressing that argument. It was asked a couple of times by mother's counsel to address the argument, essentially that the case should be decided under 105(2)(c), because there was a legal finding of fatherhood. The court essentially ignored it. So by the time father was added, husband was added, and the case moved to trial, the issue had been definitively ruled on.
Well, I mean, let me disagree with that. I mean, you said the trial judge essentially ignored it. I mean, as I read the supplemental order, the trial judge recognized that issue had been raised, but did not decide it.
I guess I read it a little differently.
Okay.
My reading of the order is that by being, having that request made to the trial court 2 or 3 times and essentially ignoring it, that is a ruling.
Well, I'm sorry, what were the other times that it was raised to the trial court?
So it was raised in 2 pretrial motions. One was the motion to dismiss
Okay, I saw
and
that
stay
one.
the genetic testing, and it was raised orally at, I believe, the September pretrial conference. I could be mistaken about that, but I think that they brought it up, and the trial court essentially said, no, this is a case between 2 presumptive fathers. It was the hearing where the DNA tests were introduced.
I mean, I'll say one thing that I thought was curious is that after the court, and the court doesn't really take it on because in my reading of the court's order, the question was whether or not father had standing. And so the court said, well, father has standing, and acknowledged that this argument had been made, but it really didn't go to whether or not father had standing. And then almost immediately after that order, there's a motion for hair follicle testing, and in that motion, husband says, hey, there's two presumptive fathers here, and you might want to know which presumptive father is better. That's what you're going to have to decide. So why don't you drug test the presumptive fathers? And I thought, okay, well, now they've dropped that. And all the way through until the end of the case, what's presented to the trial court is there are two presumptive fathers, and you have to determine which one should be the legal father.
My reading of the case is a little bit different. The other motion I just remembered was the motion to certify the interlocutory appeal, where they made the same argument about the legal finding of fatherhood, that the acknowledgement of paternity had matured into a legal finding of fatherhood. The standing
who raised
issue is,
that?
I'm sorry?
Who raised that?
Mother did, because husband wasn't a party to the case at that point. And I will also say, although the issue has not been addressed in Colorado courts, the federal courts have recognized that an objection by a co-party or an aligned party is sufficient to preserve the issue. So in this case, I think we're running into a situation where a father comes onto the case and starts repeating the same arguments that mother has made that the court has denied.
Well,
Or
it's-
failed to
yeah, I mean,
rule on.
yeah,
Failed
I
to
mean,
rule
I
on,
think there's
but-
a difference, I mean, even in terms of the federal authority. I mean, before you can get to the co-party issue, there has to be a ruling. Well, here mother raised it, but as I read the record, it was never ruled on, and husband never asked, after he joined the case, never expressly asked the court to revisit it. Is my latter statement correct?
The statement that husband never raised it?
Never expressly asked the court to rule on it.
I believe that he did. I'd have to
Okay, fair enough.
review the record, but I believe that that objection was made somewhere. It may have been mother's counsel objecting to it, but I do believe that father's counsel has raised the issue somewhere. I'm not, 100% sure that I'm not conflating the two.
Okay.
In any event, the issue was brought to the attention of the trial court, and the trial court, in its failure to rule on it, as you've characterized it, and I would agree with that characterization, after having been requested that it rule on the issue several times, declined to do so. And in my view, that is tantamount to a denial. I think the issue was raised again later, although, again, I'm not 100% sure which party raised it. In any event, as a result of the trial court characterizing the case as between two presumptive fathers, it failed to address the fact that father's voluntary acknowledgement of paternity had matured into a legal finding of paternity.
By the time he was added as a party.
By the time he was added as a party, after 60 days had run or on the date of the first proceeding, 1052C doesn't really make any exceptions. It says a voluntary acknowledgement of paternity that is filed with the appropriate body becomes a legal finding of...
Does it even say filed with, the paternity statute talks about filed with the appropriate body, but does Section C talk about who has to be filed with?
Section C does not talk about who it has to be filed with. That's correct. In this case, it was filed.
With vital statistics?
Yeah, I believe so, yes.
Who can file a voluntary acknowledgement of paternity?
I suppose any putative father with the consent of the mother who...
Where do those two requirements come from?
What two
Both having
requirements?
consent of the mother and that it can only be a putative father?
From the statute, Your Honor.
Where?
1052A1?
Okay.
I think it may say any man claiming. A man is presumed to be the natural father of the child if, and then if you jump to C, after the child's birth, he and the natural mother have married. So under the facts of this case, I guess I don't know in the universe broadly who is entitled to file that, but under the facts of this case, surely because of his marriage to mother, father was entitled to file that.
No,
But I
well,
thought they got
well,
married in July.
Yeah, they got
After the birth, that's right, Your Honor.
And I don't I don't quibble with the contention that husband had one or more presumptions. Even if the timing of the marriage, accepting into the home and holding out, he has a presumption. Where is there a limitation that an acknowledgement of paternity under subsection C, or 2C, can only be filed by a putative father? And where does it indicate that that person has to have mother's consent?
I misunderstood your question. I don't know who can file a voluntary acknowledgement of paternity. Typically, the way it works is that when a man is sort of present or around for the birth and he's not at the time married to the mother, they'll be presented with an acknowledgement of paternity.
But here's my problem with this, is you're saying he has a legal determination after 60 days. Where does it say that mother has to get notified of the filing?
105(1)(e) acknowledges this paternity of the child in a writing filed with the court or registrar, which shall promptly inform the mother of the filing, and she does not dispute the acknowledgement within a reasonable time.
So there's a need to notify mother, but not any other putative father.
There is a requirement to notify the putative father in a paternity action under section 110, I believe.
But not under.
But not under 105.
Right. So this is an opportunity to. So if somebody's in husband's position and knows that there's another putative father out there, because there has to be another putative father out there because he's
Clearly, right.
Because he knows he's not the biological father. Instead of filing a paternity action under 1, where he'd have to give notice and an opportunity to be heard, and the other presumptive father would have an opportunity to contest, he just files this without any notice to the world and crosses his fingers and hopes that 60 days will pass. But not only before a paternity action is filed, but before service of that paternity action, and then it's ball game.
Right,
that
I'm
how it
sorry,
works?
just to jump in, it's not just that he keeps his fingers crossed. He also doesn't go to the door when the process server shows up.
I would submit to you that that is a strong basis to challenge that acknowledgement of paternity or the legal finding of paternity on the basis of fraud or mistake, because that is a material misrepresentation of the reason he has executed the acknowledgement.
Well, no, it's not. I mean, how does this rise to the level of fraud? Not answering the door when a process server comes up, or heck, leaving town for 2 months. That's not fraud. That's dodging service.
Well, we don't know that that's the case. I mean, that is, I think if you review the testimony from the trial, the service issue, first of all, the server tried to serve the wrong house for a month. There were only 3 or 5 or 6 attempts afterwards. There was testimony contradicting the sole witness who testified that people were looking out the window. I mean, we just don't know. And the trial court, indeed, in the final order, found that there was no fault attributable to any party for not accomplishing service.
But even assuming that there were active efforts to dodge service, therefore allowing the 60 days to run.
I think it's immaterial, Your Honor, because at this point, the statute doesn't make an exception for service. It doesn't make an exception for a petition. The chronology is one thing, but after the voluntary acknowledgement has matured into a legal finding, the trial court is required to address the threshold question: can we set aside the legal finding? And under the facts of this case in particular, I think that there is a strong argument petitioner could have made to do that. The point is that the acknowledgement of paternity is a very heavy action and carries a lot of weight. It obligates a father who may or may not know he's the biological father to child support and all of the other sort of attendant responsibilities that come with raising a child and being responsible for a child. So after the 60 days has run, or at the date of the first proceeding, the General Assembly has determined that we afford that voluntary acknowledgement a great deal of weight. And so regardless of the service, regardless of the chronology, after those 60 days have run, the court has to address, can we set aside the legal finding? I mean, even the statute, we don't stop the legal father from his child. We don't prevent the child support obligation from being in effect, and so forth.
All right, so you filed the voluntary acknowledgement, and that essentially binds the father to the child. Now he can't walk away from it except under the DNA provision of 2 years, and under these circumstances, he has no out because he's executing it with full knowledge that he's not the biological father, right?
Well, not in this case. If you review the testimony, it's pretty, I mean, I know the trial court in its final order says that he knew from the outset, but there is no evidence in the record other than a single bit of testimony from the petitioner. Father testified that he and mother were dating at the time that mother was in a relationship or had a brief relationship with the petitioner. He testified that he was told that he may be the biological father.
I'm sorry to interrupt. Let me maybe take another run at this. So anytime that you have a potentially more than one presumptive father out there, why is it not the case that the presumptive father who's most close, who mother is rooting for, who mother wants to get the legal determination, why would that father ever actually file a paternity action and say, I am under, application of logic and common sense, I should be legally determined to be the father? Instead, shouldn't mother and putative father just go ahead, file the acknowledgement, and then dodge service?
That, I think, would constitute a reason for setting aside, I mean,
Under
dodging-
what?
Under 105(2)(c).
Is it a mistake?
It's either a mistake or fraud. I mean, dodging service to avoid a paternity hearing is fraud.
You think that's you don't think you
I
would
think
have
there's an
argued that
argument
that's
to
not
be-
fraud?
I think that there's an argument to be made, and the trial court should have had the opportunity to address it. I mean, look, the situation here is that we have a legal finding a voluntary acknowledgement that matured into a legal finding. This is his only shot to sort of address what was essentially a wrongful termination of his parental rights. His
Well, I guess-
fundamental liberty interest was
I mean-
impacted, and petitioner has multiple routes. He can challenge under 107(3), he can challenge under 105(2)(c). The due process implication is grievous for petitioner, but for husband, but it allows petitioner several avenues to challenge the legal
Well,
finding.
but the problem is, when you don't tell the trial court that this is where we are procedurally, right? Then, father can't say, oh, well, if that's where we are, then in that case, I'd like to turn to 107.3. This is great, let's do a 107.3 analysis.
What do you mean if you don't tell the trial court?
But the
where we are?
trial court thought that it was deciding two presumptive fathers, not that somebody had to overcome some legal determination of fatherhood.
Two things. I think that's one, a result of the trial court's failure to add a necessary party. And number two, that is the overarching point, is that the trial court should have waited until it had subject matter jurisdiction, all parties were added, was given an opportunity to understand, by virtue of mother's response, which was in her initial response, there is a husband here who is another father. By the time that occurred, his presumption had matured into a legal finding. There's nothing in the statute that tolls the legal finding, right? That tolls the 60 days or anything like that.
But he never raised that issue with the trial court. Instead, he just litigated this as though it was a competition between two presumptive fathers.
I think because that's the roadmap that the trial court had set forth.
And
It
sorry, I know
disallowed
you're
it.
out of time, but can I just ask another question?
Of course.
What if we said, okay, you know what, this just went completely off the rails. Why don't we send it back to see if the court wants to overcome the legal acknowledgement under 107.3? I mean,
That's what you're
what do
asking
you
for,
want
isn't
us to do?
I believe the case should be remanded so that husband can have a fair shake. This was essentially a termination proceeding where his due process rights were not afforded to him. This is the termination of a fundamental liberty interest in his child, his legal child. And the appropriate thing to do, in my mind, would be to remand the case and have the trial court afford husband his due process rights. Petitioner has the same opportunity to be afforded due process. He has, as you've pointed out, multiple avenues to challenge this. It's very unclear from the record that anybody knew or with any certainty who the biological father was. So 107.3 is surely an option for petitioner to challenge this, as is 105(2)(c).
Wait, you're saying from the record it was unclear whether or not father was the
Well,
father?
before the DNA test,
Really?
If you read the testimony, it's very clear. Both of the men testified that they were told they could be the father. Both men testified to having a relationship with mother in the summer of 2016. The only testimony in the record suggesting that, anyone was sure was petitioner's own testimony where he said, she told me I was the father, I was sure. But mother told both men that they could be the father. How, petitioner interpreted that as a certainty is unclear to me, but the record demonstrates with a great deal of certainty, and I reread it last night for this exact point. I read the entire transcript, and there is nothing in there that says when husband signed the acknowledgement of paternity, he knew he was not the father. I know that that's in the trial court's order, but I think this also highlights the issue. Had this case been decided under the appropriate statutory subsection, 107.3, for example, the trial court would have actually had to dive into that issue and address, hey, did he actually know this at the time he signed the acknowledgement of paternity? And again, the record does not demonstrate that. There is just the testimony of petitioner.
Thank you.
Thank you, Your Honors. I would ask, as I said, that this be remanded for a fair shake. Thank you.
May it please the court, I'm Ann Whalen Gill, registration number 14610, here on behalf of the biological father, the petitioner at the trial court level. I think that your questions revealed a threshold concern in this case about preservation of the issue of the husband's challenge to the trial court's orders. The mother did raise the concern and the fact that her husband had filed the voluntary acknowledgement of paternity in July, and that at the time that she filed her emergency motion was more than 60 days after filing of the voluntary acknowledgement. So her position in her emergency motion was that had ripened into a legal finding of paternity. She argued also that the father did not have standing to bring the paternity action. At that point, the paternity action had been filed in early June, and the trial court had ordered genetic testing, which was appropriate for the petition to determine that father did have the DNA to establish standing to be a presumptive father. The trial court's order on mother's initial emergency motion was that father did have standing. And then the supplemental motion said, yes, we're going forward with the genetic testing. And then the supplemental order all said, we do have two presumptive fathers, and pursuant to 19-401-10, the court makes husband a party to this action as a presumed father.
Why isn't that an implicit denial of mother's contention that he was that husband was a legal father, not a mere presumptive father?
It could be construed as implicit, but I think that once that father entered, he never challenged that in any, once husband entered, he did not challenge that. He just accepted that his position was as a presumptive father.
Why does he need to renew it if the court has in fact ruled on it?
Because there is no direct express ruling on that. You read this and it's more about the father's standing and does not really engage in an analysis of the voluntary acknowledgement.
But it does say that husband is a mere a competing presumptive father, which means it's a rejection of the contention that he is the legal parent by virtue of the acknowledgement and passage of time.
It doesn't appear to be that, but I do think that the husband then could have, once he entered into the case, he could have argued it on his own behalf, either through a motion for reconsideration, which is allowable under our rules of civil procedure.
Is it required before it's preserved? Because we're not really debating over whether he could have. It's really a matter of, did he have to re-raise it in order to have it preserved, or has the trial court already ruled on it and we just have to take the trial court's order and it can be appealed down the road?
I think that order was entered before he was a party. I think it's a gray area. I think that he should have raised it on his own behalf rather than conceding that he was a presumptive father. He repeated in his motion for hair follicle testing that he was a presumptive father. In the joint trial management certificate, he stipulated he was a presumptive father. I think that with those actions on the husband's behalf, the trial court was invited to go down the path of treating and deciding this as a case between two presumptive fathers.
Is there any reason why husband is wrong, that he wasn't the legal father?
My reading of the statute is that that voluntary acknowledgement did ripen into a legal finding pursuant to the statute, but it gave no notice to father.
Well, it
And-
doesn't have to give a notice to.
No, it doesn't have to, not under the statute that says it ripens into a finding. But I think that's where this case really went off the rails. We had a pending petition for paternity in which father was trying to establish his paternity, and the case has proceeded to the point that now we have added husband as a party to the case, but husband has never argued that a different procedure should apply. All mother argued was that his voluntary acknowledgement had ripened. There was no argument about how this impacted anything other than her motion, her claim that father had no standing.
So is it your position that husband never presented to the trial court the argument that this is not a case between two presumptive fathers, but rather is a case between a presumptive father and a father who benefits from a finding that he is the father?
I think husband did not present that.
Okay.
I do acknowledge that mother had that in her emergency motion. I think that under the peculiar facts of this case, that the husband should have been, if he wanted to argue, as he has in this appeal, that this statutory legal finding required a different process, a different procedure, that he should have brought that forward once he became a party to the case.
And he never did so?
No, I did not find that in the record, and I searched for that. I did not find such a position.
Ms. Gill, can I ask a question about what the court is doing at the stage where it determines which presumptive father should prevail? I think that husband says, well, that's a really different kind of an analysis than would happen under 107.3. Like, I think the argument is the court is not deciding best interests of the child. It's not deciding just and proper under the circumstances. If it's not deciding those things when it decides between two presumptive fathers, then what is it deciding?
I think that under 105, with the two or more presumptive fathers, and the NAH case, that the trial court has to determine in the best interest of the child, considering policy and logic, which presumptive father should be declared the legal father.
I guess, what I'm getting at is, if we were to say, well, I think we'll send this back, and then you can come in under 107.3 and try to say, well, I'm the biological father, and this is in the best interest of the child, it sort of seems like, well, maybe the court already decided that. So what would be the point of sending it back?
I don't see a point in sending it back. I think that there was a hearing in which all three adults involved in this case testified as to their view of what was the best interest of the child. And there was very little discussion of the statutory framework, and the trial court's order did not discuss the statutory framework under which it was deciding. It did discuss the NAH case and the policy and logic statement
Well,
in
the
that.
statutory framework was subsection 1 of 105, right? It's the competing presumptions.
I think so, but that was not expressly articulated. But to try to answer Judge Harris's question, I don't see that a new hearing under 107.3 as to the best interest of the child is going to be useful. I think best interests have been addressed. I think that 107.3 establishes that when you've got DNA tests that establish that the father has more than 97% likelihood of paternity, then you have to address the whether it's just and proper under the circumstances and in the best interest of the child.
107.3 really isn't designed for these sort of circumstances where somebody else, a non-biological father, has acknowledged and the biological father wants to challenge. It seems to me that 107.3 is pretty clearly written for the circumstances under which somebody signs an acknowledgement, but within the first 2 years of the child's life realizes that he's not the biological father. So in this case, it would be a challenge by husband, not by biological father. 107.3 doesn't seem to be set up for this circumstance. Instead, this circumstance seems to be contemplated by the fraud, mistake, or duress. Because here, interestingly enough, husband would be fighting this effort to set it aside, and now suddenly it's in his interest to say, when I signed the acknowledgement, I knew I was not the biological father. And under 107.3, that conclusively forecloses relief under that section, which seems very bizarre that should be the avenue that a biological parent would take to challenge an acknowledgement executed by a non-biological parent.
This case has certainly had its circular aspects in trying to reconcile the competing statutes, because I think that none of these statutes contemplated the circumstances that we have here.
Actually, couldn't you argue that the statute did contemplate it? Because you have subsection 2C, which expressly talks about filing an acknowledgement and waiting 60 days, and it's a conclusive conclusion, whereas subsection 1 has a provision that makes a father who executed an acknowledgement, but before that passage of time, a mere presumptive father. So I mean, these can all be harmonized. I think there's a troubling aspect to this that I explored with counsel, but I don't see any discontinuity here in the statutory structure, and that 107.3 is really for the non-biological father who signed an acknowledgement under the misapprehension that he was the biological father, and just isn't really. It's kind of a red herring under the circumstances that we have. What do you say to that sort of harmonization of this statutory scheme?
Well, I think that there's got to be, as you discussed with opposing counsel, a mechanism, particularly here where we have a father who initiated his paternity proceeding before the voluntary acknowledgement by husband. He's got to have a mechanism by which he can move forward in his efforts to establish himself as the legal father.
And if he wants to do that, he can file the petition anytime after he's aware of conception and before birth, right? It doesn't, a paternity action, I believe, can be filed pre-birth. And so he could file that, get it served, then there's no way that the scenario that I talked about of mother and husband sort of working to circumvent this through a voluntary acknowledgement, that's his way to prevent it.
I disagree with you if I heard you correctly. The petition in paternity can be filed pre-birth or after birth. In this case, it was filed after birth.
Probably with the understanding that he was filing it before birth. Isn't it identified as an unborn child in the petition, even though it was filed after birth?
The petition did state unborn child. He knew it was after the due date, but he had no information. He attempted service on mother at the address he had for her. And there were multiple attempts on service, as the transcripts reveal. But the process servers even stopped mother on the street and asked, can we arrange for service? And was unsuccessful in obtaining service. I would take issue with opposing counsel's characterization of the court's order in saying there was no fault in the delayed service. I think the actual phrase the court used was, "I am assigning no blame." I think the trial court did not want to go down the path of, at the trial, father had raised an argument about unclean hands and equity, and the trial court said, "I'm not going down that path, so I'm not assigning any blame about the delay in service."
Or what if it could also be characterized as it didn't need to reach that issue given how the case was postured? But if the case is repostured as an attempt to set aside a conclusive determination under 2C, then that issue becomes front and center, doesn't it?
I think it does.
Well, and can I just follow up on that? Why does it become front and center? Because if husband or mom was dodging service, then what? Then that's fraud, duress, or mistake?
I think that's the argument, that the evading, that delayed service was an evasion of service, and that would fall under a fraud, duress, or a mistake as required to proceed under 2C.
So that would be your argument on remand, right? And it seems like you may have some sort of concession from the other side that somehow that if this was an intentional effort to evade service, knowing why they were doing this to let the declaration mature into a legal finding, that would be sufficient to establish either, he says, fraud or mistake. Are you willing to accept that as a concession?
I don't want to concede I wasn't trial counsel, but I think that's the argument that would be presented. I thought it was telling that mother's emergency motion was filed approximately 3 days after the 60-day maturation of the voluntary acknowledgement. I think that she was ready. If you read that emergency motion, that's not something a lawyer whipped out in a single day. They spent some time preparing that. So I think that the chronology itself speaks to being prepared to utilize the 60 days as a sword against father.
I mean, I tend to agree that the chronology is a little suspect, but I also don't see anything other than the fraud, duress, or mistake that prevents husband from using the 60 days as a sword.
That is
And to be fair, I do agree, I think, that, I mean, it seems to me that the statute is trying to encourage the father who's there to take responsibility. And so the statute says, you know what, if you do that, if you take the responsibility and you step up, then yes, then the presumption is going to go in your favor. There's going to be some benefit to doing that.
Yes, I would refer you back to NAH, which obviously is distinguishable and not having involuntary acknowledgement, but there is an in-depth discussion about presumptions of paternity and that they are almost always rebuttable. I think that there's a strong argument made in the NAH case that the presumptions should almost never be considered conclusive. And I think that here, with the voluntary acknowledgement ripening into a finding, we've gotten into that area of a conclusive presumption.
No, because
Not quite, because
it's a legal finding. The
Yeah.
presumptions are listed in subsection 1.
Okay.
And they're mere presumptions at that point. They carry a lot of weight. They can only be rebutted by clear and convincing evidence, and there's a whole procedure for that. But they are mere presumptions that are rebuttable. Subsection 2C is no longer a mere presumption. It is a legal determination. So it's in a category all its own, and I don't know that NAH was really addressing that.
No, it wasn't, because that was not a factor in that case. But I liked the discussion of rebuttable and conclusive presumptions. I have not found direct authority addressing anything other than 2C when there is a legal presumption. But here, getting back to the whole issue of preservation, is that although mom did argue it, the court decided that the father did have standing. There was never a request for the court to treat this as a 2C proceeding and go in that direction. It's just father has standing, and now let's move forward with 2 presumptive fathers. preservation, I think, is a threshold issue in this case. I would ask you to affirm the trial court's order finding that father is the legal father that was in the best interest of the child. Thank you very much.
Thank you, counsel. The case will stand as submitted, and a written order will issue in due course. I want to thank everybody for their excellent briefing as well as their arguments this morning. This was our final case on this morning's docket, so we will be in recess if the bailiff would so announce.